Okay, good morning. I'm here with Brandon for our regular weekly construction question time. This week, Brandon's going to be talking about contra proferentem. So good morning, Brandon.
Morning, Julie.
Answer this question for us. What is the contra proferentem rule and how does it operate in practice?
So thank you, Julie, for the question and introduction. So the contra proferentem rule states that where there is ambiguity or doubt as to the meaning of a provision within the contract, then the provision will be construed against the party who is seeking to rely upon it. So the question that follows from this is, when will there be an ambiguity? So there'll be an ambiguity when a provision is unclear to the effect that it can have two different meanings. So the best way to explain this is by way of an example. So let's say there's a contract between two parties and a provision of the contract provides as follows: that the sum included in the application for payment will become due 10 business days after receipt of the application for payment. So that's the provision in the contract. Now, of course, business days, which is the one which is included in the wording of the clause, is a defined term. It's capitalized in the contract, which means it's a defined term. So we go to the definitions of the contract. Now, the problem in this example is that the definition of business days has actually been omitted from the contract. So there's no definition despite it being capitalized. What follows from this is that there are two different meanings, or at least certainly two, that can apply. You could have the probably more standard interpretation, and that business days means Monday to Friday, excluding bank holidays. However, in this example, given that the contractor and his normal business working days is actually in fact Monday to Saturday, excluding bank holidays, we therefore have two different interpretations because of the lack of definition of business days. And therefore, because of this, there's ambiguity, two different meanings, and therefore the contra proferentem rule could apply. So this also example just demonstrates how easy it is to leave doubt in a contract and how easy it is for there to be ambiguity. I'm now going to talk about a recent-ish case law and how the courts have been applying the contra proferentem rule, and then discuss the implications of that, and then what is important, following that, the conclusion of what's important and what you should make sure you do when entering into contracts. So the case is Persimmon Homes versus Ovi and Arup. Now, I'm first going to briefly explain the conclusion, and then I'll actually explain the facts of the case and look at it in a bit more detail. So the conclusion of the case is that the contra proferentem rule has a limited role now, and that the courts are reluctant to apply the contra proferentem rule, and it will only be reserved in cases of genuine ambiguity. So it's very important, therefore, to make sure that the contracts you enter into are very clear and that what you intend it to mean is clearly reflected in the words used. So now let's look at the case in a bit more detail. In this case, there was a developer and an engineer, and the developer was seeking to bring a claim against the engineer following the discovery of asbestos on site. Now, there was obviously a contract between the developer and the engineer, and in the contract there was an exclusion clause, and the exclusion clause provided that the engineer's liability for any claim in relation to asbestos was excluded. The developer, however, was arguing that this clause was ambiguous and that therefore the contra proferentem rule should apply, so that the clause should be construed against the party seeking to rely upon it, i.e. construed against the engineer because they're seeking to rely on the exclusion clause and exclude their liability for negligence in failing to identify the asbestos. Specifically, what the developer was seeking to construe the clause to mean was that as follows: limited to the exclusion of liability for causing the spread of asbestos. Now, of course, this meant that if this was the correct interpretation, that negligence would not fall within the exclusion, and therefore the developer could pursue a claim against the engineer for negligence in failing to identify the asbestos on site. The court held in this case that the clause was not ambiguous, it was clear, it did not have two different meanings, and it was very clear, and therefore the contra proferentem rule could not apply. What it also held in this case, which is why it shows the limited application of the contra proferentem rule, is that when you have a commercial agreement between two sophisticated parties who have equal bargaining power, then the courts are reluctant to intervene, and instead the natural meaning of the words will be used. So, conclusion from this case, the developer could not pursue a claim against the engineer, and that the exclusion clause was wide enough to cover all claims in relation to asbestos, including negligence. So, conclusion, therefore, is contra preferentum rule, although it may have some small bite, it will only be reserved in cases of genuine ambiguity, perhaps given linking to the example of the business days, because that's genuine ambiguity and not defined. However, you shouldn't rely on the contra preferentum rule, and instead you should ensure that contracts are well drafted and free of doubt and ambiguity. So, if you have any questions on interpretation of contracts that you've already entered into, both as an employer or a contractor, or alternatively are about to enter into a contract and you want to make sure that the clauses clearly reflect what you want them to reflect, then please do not hesitate to contact me and we can look into this further. My email address is brandonsilver@silverllp.com. Thank you for listening.
That's great, Brandon. Thank you very much. And we look forward to seeing you next week. Next week, can you give us a teaser? What will we be talking about?
Yeah, so next week I'll be talking about repudiatory breach of contract and what are the consequences of repudiatory breach, a question we commonly get asked by both contractors and employers who have entered into contracts.
Brilliant. Okay, we look forward to hearing more on that. Thank you for your time, Brandon. We'll speak to you soon.
Thank you, Julie.